We're going to move to Craig Ackermann now. Craig?
Thank you very much, Desiree. And again, it's a pleasure to be here. I'm going to do my presentation with my good friend Aashish Desai, who's also a lawyer out in California. We represent truck drivers in all kinds of cases involving unpaid wages, trucking school fraud, all sorts of things, misclassification. We're going to kind of go back and forth. Aashish and I are going to try to unravel some of the chaos. It used to be a statement. The interesting thing is we're both kind of from Texas. We both went to law school here in Texas. I grew up here in Texas.
Well, I was going to say the interesting thing is that we both grew up in Texas. We both went to law school in Texas, right? I went to University of Houston. He went to Texas, which is where I went to undergrad. And we both moved to California to practice law.
And then somehow he got my tailor and he copied my outfit for today after all that. So I wanted to start out with an interesting topic. How many truck drivers here are either over the road or line haul or paid by the mile? Okay, so we got a fair percentage, maybe about a third. How many are local drivers who are hourly? Not too many. One or two. Okay. So,
and are you based in Texas or somewhere else? Everyone in Texas, though, right?
Yeah. So, you know, there used to be an expression, as California goes, so goes the nation. I don't know if that's true anymore, but we've noticed a lot of the things the last couple of years. I want to talk about the important topic of detention time, rest breaks, non-productive time, waiting time. For truckers who are paid by the load or by the mile or on any kind of piece rate, this is an issue that comes up all the time. And I want to recognize Alan and Donna Smith, who've been fighting for this issue on behalf of truckers for probably more than 20 years. Trying to recognize the fact that truck drivers should be paid for all time worked. And this is a principle that obviously Aashish and I hold very dear. What's interesting is if you think about it, under the US law, federal law, something called wage averaging is allowed, where you take the amount of time you worked over the whole week, you divide the amount of wages you got, and as long as you earn $7.25 an hour, that's legal. But not every state looks at the minimum wage that way, and including California. A lot of states look at it, you got to look at it each hour. Did you get paid minimum wage for each hour? And you're not allowed to average out the pay that you get for certain things to cover other things. So if someone tells you they're going to pay you 35 cents a mile, you're getting paid for when the tires are turning for that specific task. And that doesn't cover the time you're waiting at IKEA or whatever it is, the 3-4 hours of detention time. Now, to be fair, a lot of the industry does have policies that after a certain amount of time, maybe 2 hours or whatever, they'll start paying detention. Some companies don't have that, and even for those that do, why is it that the truckers have to basically eat the first couple hours of time when they're waiting around at the dock? So it was actually Aashish's case back in, I think, 2012, 2013, against a company called McLean Trucking, that in California, a federal court in California ruled for the first time, actually I think it was 2011, Aashish, now that I think about it, that non-productive time for truckers has to be paid separately and hourly, and wage averaging isn't allowed in California. So that really opened up a whole new way of looking at things, which is kind of, I think, revolutionary, kind of groundbreaking for the industry. A lot of carriers don't like it, don't understand it, are still trying to fight it, you know. But
you know, Craig, let me just interject real quick. One of the things that we're doing now is that although we created this great law in California, and it probably applies in a couple of other places, maybe New York I can think of, and some other states. But one of the interesting things is, even if you're a Texas-based driver, let's say you travel all the way to California. Let's assume you have a layover in California and you spend more than 1 day there. And then you come back to the great state of Texas. Well, spending that 1 day in California now is going to provide us with a basis of saying to the employer that during the time that you're a Californian working, the California law now is that if you have people come into California, take advantage of our sunny state and deliver goods here, then you have to comply with the California wage laws if your drivers are there for at least 1 day. So another area to think about, and we're both thinking about this when we're going out of the box to try to make sure that you guys are paid for everything that you can get paid for. That's one of the interesting things that maybe everybody here should think about.
Yeah, that's very true. And since that case Aashish did back in 2011, the California legislature and the courts went ahead and codified that as the official law of the state. So now, any driver in California, whether they're a resident or whether they come in and work for a day or more, they have to be paid separately and hourly for all of their on-duty, not driving time, which would include waiting, loading, and unloading. It would include rest breaks in California. It would also include fueling time, paperwork. That stuff has to be paid separately and hourly. That's a movement that's pretty revolutionary. It's no longer just limited to California. The state of Washington has now adopted similar principles for rest breaks, and the Washington Supreme Court's going to be ruling in the next couple of months on whether the non-productive time also has to be paid separately and hourly. But the thing is that as these cases are brought, companies are having to face up to the possibility of actually changing their policies across the board, not just for one state, but maybe regionally, if they're a regional carrier. Because obviously, if they've got some drivers in California who are getting paid for certain things, the other drivers are going to say, well, hey, why don't I get paid when I'm in Henderson, Nevada, doing a pickup there? I got stuck there for 3 hours. Why don't I get paid for that? So it's really kind of, Aashish, I don't know if you've noticed, have you noticed any companies changing their policies, on an across-the-board basis, or is that something they're concerned about in any of the cases that you've brought or been involved in?
In the 7 years I've been involved in the trucking industry, and you guys, some of you have been involved in a lot longer than I have, I've noticed one thing for sure. These companies don't do a thing unless they have to. And the only way I have noticed these trucking companies changing, even when you have them debt to rights, even when you have their hand in the cookie jar, we got a great violation, they'll still say no. It'll still take 2, 3, 4 years of usually litigation. The way they change is if they're in it, they're going to get hit for something worse. Then they make a calculation to say, well, looks like we're about to get hit for something worse. We might as well pay, these claims. But it's not until you take them all the way down there.
Industry for many years tried to argue that they don't have to comply with the state and local laws. They only have to comply with DOT and the federal laws, and that the federal laws should preempt, which means basically to nullify all the state and local laws. And at one level, you can kind of understand it, the simplicity, particularly if you got an interstate company operating in a number of states. They were concerned that this raises a level of complexity. But those arguments all lost in the courts. And there was a major case a couple of years ago, Dilts versus Penske, went up to the Ninth Circuit Court of Appeals, and the court said, no, if you're operating in a certain state, the meal and rest break or these separately paid for non-driving time obligations, those are not preempted by federal law. The United States Supreme Court refused to hear that case, so that became the law of the land for the entire West Coast. Recently, J.B. Hunt tried to get the U.S. Supreme Court to rehear that same issue again, and the court said no. So, and that's the only federal appellate court, one below the U.S. Supreme Court, that's ever addressed that issue. So,
Craig, of course, then the trucking industry gave up, of course, right? They went all the way to the Supreme Court. The Supreme Court said no twice. They lost in the Ninth Circuit. They lost in every district court imaginable. Surely they gave up then, right?
Well, if you can't win in one forum, you got to try a different forum. And that brings us to what's happening now on the legislative front, which is for the last 5 consecutive years, Representative Denham, who's from Modesto, California, who's been getting quite a lot of money from the trucking industry, according to the public filings, has been trying to add on to pretty much every single funding bill that has anything to do with trucking. Transportation, Housing, Urban Development, Federal Aviation Authorization Act, the Highway Act of 2015, the Omnibus Bill last year, the Omnibus Bill this year. There's always something called the Denham Amendment. And the Denham Amendment basically says, it's a law that says no trucking company involved in interstate commerce has to comply with any state or local law that will require them to pay more than they have to pay under federal law, which is $7.25 an hour. Well, if that amendment ever gets passed, and by the way, it has now passed the House of Representatives for the second time as House H.R. number 4, and it's the Federal Aviation Authorization Act. Congress has until September 1st to fund the whole government. Usually they kick the can down the road with these continuing resolutions that takes them until like March to do it. So they're probably not going to do it on time, but this H.R. 4 is now on the Senate side. If the Senate passes it, it'll probably become law, and that will forever ossify or solidify the industry's right not to pay separately and hourly for any of this stuff. So we're hoping that doesn't get passed. Alan and Don at Desai have done a lot of social media campaigns to try to raise awareness of this issue amongst truck drivers. And of course, the ATA and the carriers are very much against this, and they put out a lot of information saying, this is going to force drivers to take breaks, and there's a lot of disinformation. I'm actually going to be debating, I think, the head of the ATA on this issue on Road Dog Radio in a couple of weeks coming up. Nobody's going to be forced to take anything in Washington State. Whether you take a rest break or you don't, you still have to be paid separately and hourly for the extra 10 minutes every 4 hours. In California, the company has to make the break available. If somebody wants to waive it, they're allowed to do that. All that stuff is being put out there because, in my opinion, the industry would like to maintain the current flexibility that they have to pay as little as possible and to have the drivers eat their non-productive time, et cetera, because that foists a huge amount of cost onto the drivers, and they don't want to be forced to have to, by any state, let alone California or Washington, or no carrier wants to be forced to change their policies by a state law, particularly on the left coast. But not everything that comes out of California is bad. This happens to be a good one because, as Alan and Don and other people have put out there, there's 15, 20 hours a week that a lot of truckers are working without getting paid, right, Aashish?
When you take a look at this, all we're trying to do is make sure truckers get a fair wage. You guys are already doing the work. There's no question about it. When we come in there and ask for money, we're not asking for a windfall. We're asking for the 15 minutes of pre-shift time and 15 minutes of post-shift time, even though it might take a little longer. That's not unheard of. Currently there would be no compensation for that in any company.
You're talking about inspections?
Inspections, the pre-shift inspections that everybody has to do. In Texas, you wouldn't get a penny for that. Why? Because it would just be part of your compensation. Here's your compensation. It's based on driving. It's based on 33 cents a mile, 27 cents a mile, 43 cents a mile. Well, I ask you, if your wheels are not rolling, how are you earning any compensation? Your wheels have to be rolling for you to make your 43 cents. So when you're doing your pre-shift inspection, your post-shift inspection, waiting for a customer, doing all the other stuff that you guys are doing, the wheels are not rolling. You're getting paid 45 cents per hour, but guess what? No one's going anywhere fast. You're sitting still. So those are the kind of arguments we make, and we win consistently in different places. And that's the kind of stuff that we're trying to get, and this Denham Amendment stuff is going to wipe that out.
Thank you very much for listening to us on these cutting-edge issues of detention time and rest break pay. We're going to hand it back to Desai now.